All right, just for the record, we did have a chance to meet in chambers to discuss some of our upcoming jurors, and we have agreed by stipulation of the parties, numbers 101, 106, and 107 will be excused for cause. Juror number 102 was excused last night by the jury office. That person is no longer a Hennepin County resident and is thus ineligible. That leaves us 3 people, 2 that will do the group advisory and instructions and try and get through them before lunch. But as is often our habit, maybe continued after lunch for one. But in any case, since we would only have one on for the afternoon, jury office is trying to contact an additional 2 jurors to be essentially on standby to come in if they are able. They were not told last night that that this was their day to come in, so it's more of a see if it's possible so that we can fill up our afternoon if necessary. So, and we don't know the answer to that. I'll advise counsel as soon as possible. So with that, if we can bring in the next group of jurors. And you can be seated. Good morning. First of all, can you hear me? Give me a thumbs up if you can hear me. Excellent. We have hearing assistance devices if you could not hear me. So, in any case, my name is Pete Cahill, and I'm one of the judges of the district court, and you have been summoned as potential jurors in the case of State of Minnesota versus Derek Chauvin, which is a criminal case related to the death of George Floyd on May 25th, 2020. A person charged with a crime has a right to a fair trial before an impartial judge and an impartial jury. In order to make sure the jurors who are selected are impartial, the law provides that the court and the attorneys for the parties may ask questions to the jurors. Those questions must be answered under oath. Now first, thank you for filling out the questionnaire and mailing it back to us. That gives us a lot of good information to start this jury selection process. Your contribution to the important and serious matter at hand is best served by continuing to provide full and complete answers to the questions that you'll be asked today. Those questions will follow up on issues from the questionnaire and possibly other topics. Now, after the questioning is over, the attorneys will have the right to excuse some of you from service on this jury, and I may excuse others for cause. In either case, it does not mean that you are not a fair and impartial person, and so I ask that you not take any offense in being excused. Also ask that you not take any offense in any question that you may be asked. We must pry to some extent in order to explore some opinions you might hold and hear about experiences that you have had that might affect your ability to serve in this case. The defendant, Mr. Chauvin, has been charged with murder in the second degree and manslaughter in the second degree. Now, in the normal course of a trial, charges might be added or subtracted from those charges, but those are the charges as it stands today. To the charges, the defendant has entered a plea of not guilty, which is a denial of each and every material allegation in the charges. I'm now going to have the participants in the case introduce themselves in order so that we can find out if you have any kind of relationship with them, a friendship, acquaintance, or a professional relationship. First for the state.
Thank you. Good morning. My name is Steve Swisher and represent the state of Minnesota.
Hello, my name is Christine Aronakis and I'm assisting with the prosecution. Good morning. Erin Eldridge for the state of Minnesota.
And Mr. Nelson, if you'd introduce your client.
Good morning. My name is Eric Nelson. Along with co-counsel David Ross, we represent the defendant.
Do either of our jurors know anybody in the room? If so, raise your hand. Okay. Anyone in the room know anybody who works for the Minnesota Attorney General's office? Because there might be other attorneys who might be appearing in the trial itself, including Assistant Attorney General Matthew Frank, Attorney General Keith Ellison, Mr. Jerry Blackwell, or anybody else in the Attorney General's office that anyone recognizes. Okay. Now, you've been given a copy, excuse me, you have been given a copy of a list of potential witnesses. Please review it before you are questioned individually if you have not done so already. You'll be asked if you know anybody on that list. Now, one of the things the attorneys may not do in jury selection is to instruct you on the law. But I do want you to be aware of some of the basic concepts that apply in every criminal case, so that you may keep them in mind as you answer the court's and the attorney's questions. So I will instruct you as follows. First, the charges against the defendant are not evidence and they create no inference of guilt. No member of the jury should in any way permit himself or herself to be prejudiced against the defendant because a charge has been made against him or because he has been placed on trial. The defendant is presumed innocent of the charges made against him, and in order for you to find the defendant guilty, the state must prove guilt beyond a reasonable doubt. The defendant does not have to prove his innocence. The presumption of innocence remains with the defendant throughout the trial unless and until he has been proven guilty beyond a reasonable doubt according to the law and the evidence admitted at trial. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. If you serve on this jury, you and your fellow jurors will be the sole judges of whether a witness is to be believed and of the weight to be given a witness's testimony. There are no hard and fast rules to guide you in this respect, but in determining believability and weight of testimony, jurors may take into consideration the witness's interest or lack of interest in the outcome of the case, their relationship to the parties, their ability and opportunity to know, remember, and relate the facts, their manner, their age and experience, their frankness and sincerity or the lack thereof, the reasonableness or the unreasonableness of their testimony in light of all the other evidence in the case, and any other factors that bear on believability and weight. If on this jury you should in the last analysis rely upon your own experience, good judgment, and common sense. Now there are certain things you should not do during jury selection. You are not investigators, you are not to go out to do any looking, and you are not to speak to anyone about this matter. You are not to use the internet to look for information about this case or about the law. Above all, you must not talk to anyone who is involved, the lawyers or the witnesses. Do not be offended if the attorneys, parties, witnesses, or spectators do not speak to you. They know it would be improper to contact you during the trial, and so they will, except for the normal jury selection process, and they will confine themselves to a brief greeting. Now, during the selection process, your family and friends will be curious as to what you are doing. You may tell them that you are on a panel of potential jurors in a criminal case, and that is all you should tell them. Since that is all you should tell family and friends, that is all you should tell the general public. So, please, during these proceedings, refrain from using Facebook, Twitter, or other social media to announce that you are a potential juror or to comment on this trial. You may access such social media tools, except for the news feeds that you might have, but please do not publish any information about the case or your thoughts about the case. You do not have to stay away from people and refuse to speak to them. Do whatever you wish, but do not talk about the case and do not talk at all to anyone involved in it. Because of the nature of the charges, this case is receiving media coverage. Do not read about this case in the newspapers or online. Do not listen to news about it on radio or television, for that matter, in any media. This trial, including jury selection, is being televised, but no video of you or any other juror will be taken at any time, now or during trial if you are selected. Also, your name will not be used in the courtroom. You will only be referred to by your random number to protect your privacy. The audio of anything you say will be broadcast unless we need to discuss something that is deeply personal, extremely sensitive, or embarrassing, or likely to specifically identify you. In those cases, I will specifically order that the audio not be broadcast. In that case, you will still have to answer questions on the record, but without audio or video broadcast outside this courtroom. Now, juror number 99, if you could remain, and we'll start with individual questioning with you. Juror number 103, if you could follow the deputy back to the other courtroom. Okay, juror number 99, if you could come on up to the seat here. Good morning.
Good morning.
Before we start, a couple things. I'm going to swear you in so that all your answers are under oath. If you could raise your right hand. Do you swear or affirm under penalty of perjury that you will truthfully answer all questions about your qualifications to serve as a juror?
Yes.
All right. Will you have plexiglass in front of you? We have plexiglass between us. I'll continue to wear a mask. Attorneys also have plexiglass in front of them. We have a lot of precautions which will permit you, if you wish, to take off your mask. Whether you wear it or not is totally up to you. But in either case, mask on or mask off, if you could make sure you're close enough to the microphone so that we can hear you clearly. First of all, thank you for filling out that questionnaire. It was very helpful to get us good information to start with. Was everything true on the questionnaire?
Yes.
Any changes or additions to the questionnaire?
No.
All right. When the lawyers are asking you questions, they might focus on specific questions. And since it was a few months ago, they'll probably read you the question and your answer. Not to be confrontational, but just to refresh your memory about what you said. Because it's been a few months, we find that people want to add things that they forgot to put in there, or correct things that were inaccurate, or even maybe an opinion has changed or evolved. And so the bottom line being, we'd like you to feel comfortable giving an answer that's different from the questionnaire. The only requirement, of course, is that it be truthful and honest. But feel free for it to be different from what's in the questionnaire. You weren't supposed to read any articles or watch any media about this case, but we understand it's been a couple months since you filled out the questionnaire. And given the amount of coverage of this case, you inadvertently might have been exposed to some news. Either about this case or related cases, pretrial matters, anything that you can recall that you've been exposed to in the meantime, between the questionnaire and today.
Yes, the settlement.
Okay, what do you recall of the settlement?
I just saw, on the news, the $27 million settlement that the Floyd family got.
Okay. And how do you think that would affect your decision here? If at all?
Not at all.
Okay, and let me be a little more specific. Question 10 in part 1 was basically, can you be fair and impartial? And at the time you filled out your questionnaire, your answer is yes. Do you think hearing news of that settlement may have moved the needle, so to speak, moved you a little off being impartial at all?
I would think I'm more partial now.
Okay, and to which direction?
Of the case?
Yeah.
I would think he's not guilty.
Okay, from the settlement? Okay. So if you're in the middle, that might push you the other way?
Mm-hmm.
Towards not guilty?
Correct.
Okay. I do note that you've got in your background, you've worked with the police department at South Lake, Minneapolis, or something out in the western suburbs. I can't recall exactly which one. Do you think that relationship, having worked there, and obviously it gave you favorable opinions about the police, do you think that would also kind of maybe move the needle a little bit?
Yeah.
So I'm sure it was an honest answer at the time you filled out the questionnaire. Now as you sit here today, do you think you can be fair and impartial?
I don't think I already have my opinion on it. I think it's...
And is it pretty well entrenched about it?
Yeah, I want to see the facts and evidence. I think there's a lot out there that we don't know, and the media puts out a lot of information that... So I'm pretty sure I'm partial.
Okay, and it would be hard for you to put aside
Correct,
the
yeah.
opinions you have. All right, I'm going to excuse you from this panel and from jury service actually completely. You don't have to worry about being called back on another case. All right, thank you. Juror 103.